Call the meeting to order. Please rise for the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Welcome to the August 5th, 2025 Post Falls City Council meeting. Shannon, please note that all council members are present with the exception of Mr. Davis, who is excused tonight. And we do have one announcement. The city is updating its comprehensive plan, a long-range guide for growth and development in Post Falls. We're asking for your input through a quick online survey. Your feedback will help shape the future of our community. The survey closes August 11th, so don't miss your chance to weigh in. Visit postfalls2045.org to participate. Field, I'm going to ask you to address a topic tonight.
So I know a lot of people have turned out to discuss property in the county, specifically the Dorsey property. Just wanted to remind everyone that citizen comments are there for council to hear concerns, not necessarily to engage in a discussion, and they should be concise and not repetitive. So please listen to the person before you and try not to just repeat the same thing. And I also wanted to to let the council know that staff has been aware of this issue. We have had internal meetings on this. The staff has also met with the owners of the property on 2 separate occasions over the last week or so. At this time, we are trying to work through some proposed solutions. At this time, they are not amenable to those proposed solutions, but we are working on that, and one of those includes not having to annex at this time as well. So,
Field, can we further that? So not having to annex, which means it would not have to hook up, if the house is built, would not have to hook up to sewer at this point.
that is correct. We are exploring options for them to be able to accomplish what they need to in the county.
Without sewer hookup, without frontage improvements, so trying to work out a solution for the owners.
Yep.
So folks, we are, again, if you want to talk, we'll let you talk, but understand we are trying to work this out with the owners. We're not going to force them to annex in. We're not going to force them to hook up to sewer if it goes forward. One thing I would caution, though, is if you do speak, we're going to treat everybody with respect. We're going to listen to everybody, and hopefully there's no cheering, there's no comments from the crowd. Please, if you're going to talk, we need to have it be recorded, and we will listen to you. But again, bear in mind, we will give you the opportunity to visit, but we are trying to work out a resolution with the property owners. So, and that will continue, regardless of any conversation or discussion tonight. We will continue to try to come up with a fair and equitable solution for the property owner. Are there any amendments to the agenda tonight?
There are none tonight, sir.
Any declarations of conflict?
I would like to recuse myself from 2 items.
Okay.
If that's okay. Item E on the consent calendar and item A under action items for unfinished business.
Okay. Do we need any reason on that, Field, or is that just, okay, thank you. Would you please present the consent calendar?
Item A is minutes from the July 15th, 2025 City Council meeting. Item B is accounts payable for July 16th through August 6th, 2025. Item C is the May cash and investments report. Item D is consent to assignment and assumption agreement, Post Falls Landing Development Agreement. Item E is MVBC annexation grants of right-of-way and easement, ANNX-23-6. Item F is Montrose 18th Edition Subdivision Construction Improvement Agreement. Item G is fiscal year 2026 intergovernmental agreements for prosecution services. And item H is police department IT assets disposal.
Any questions on the consent calendar?
I would move to approve the consent calendar as presented.
Question about that. Do we need to, was the consent calendar item that you need to recuse
Yeah,
yourself
do you want
from?
me to just say yes without the,
Yeah, what you can do is just say, is to vote aye, except for item E,
yeah,
which I
that's
abstain.
perfect.
And you've already put your abstention on record, so.
Okay, perfect, thanks.
Second.
Motion second, further discussion. Roll call, please.
Stick leader. I with the exception of item E. Flu,
Aye.
Malloy,
Aye.
Ziegler,
Aye.
Westland.
Aye.
Motion passes. Thank you. Next up is public hearing. We do have one tonight. That is the vacation of Villa Point North, file number VAC 25-2. Open public hearing. I should say, if anyone wishes to speak on this public hearing, there's a form back of the chambers. Please fill it out, give it to our clerk, and we'll let you speak.
Good evening, Mayor Jacobson, Council President Malloy, and members of City Council. John Manley, Planning Manager, here to introduce the Villa Point North Vacation VAC 25-2. Should be a fairly quick one here. So the owner is Jeff Scott, and he's present tonight to talk about this project. And the applicant for him was Merle Van Houten. So they're requesting a vacation of a 10-foot utility easement running through the center of some lots that were part of the Villa Point North subdivision. The easement was solely on the benefit of those parcels. There's no utilities that have been installed that are public interest or private interest. The site here, as you see here, is on East Mullen Avenue, just on the northwest corner. They're hatched in the black. In red there, you can see here's the plat that was platted on that northwest corner, the 8 lots and the 10-foot easement that ran through those lots. I think the applicants can speak to why the easement was proposed and why he encumbered that upon himself at that point in time. But he can also speak to why it's no longer needed. But staff reviewed it and doesn't see any concerns of vacating this easement. Here's the agencies that were notified. Here's who we heard back from. Collectively, there's really no comment and no concerns about vacating this easement. You have any questions for me?
Questions,
on
Mr. Manley?
this?
So this was just put there for the benefit of those parcels, and the design changed and it's not needed in that spot anymore, is that correct?
Yeah, and I think they've had some conversations with Avista. I think that was primarily why it was placed there. Avista no longer wants it there, and they are looking at different designs, but I think there's other alternatives to run utilities that is more attractive for Avista. So the applicant no longer desires it there, and the only way to get rid of it is to go through this vacation process.
Got it.
The applicant wish to speak?
I'll let him come up. Back.
Hello, council. So the original plan.
Name for the record, please. I'm sorry.
Jeff Scott.
Thanks, Jeff.
The original plan was to have 8 townhomes with a courtyard slash utility easement for Avista, primarily Avista, and then separate detached garages. So Avista said they cannot and will not use that easement, so I don't know why we put it in to begin with. And by vacating that, it would allow us to put attached garages to the units as opposed to detached garages. So it doesn't benefit any other parcels. It didn't exist prior to us doing the subdivision, and it has never been used, will never be used. So just trying to vacate it to open up some options for different product.
Thank you. Any questions? Pretty straightforward.
Pretty simple, yep.
Anyone wishing to testify?
We have none.
I thought maybe someone with getting a phone call wanted to. I'll close the public hearing. Thank you very much. I don't think there's any need to rebut because nothing else was said. Council, how would you like to act on this?
I would move to approve the vacation for the Villa Point North, file number VAC-25-2.
Second.
Motion seconds. Further discussion. Roll call, please.
Flu,
Aye.
Malloy,
Aye.
Ziegler,
Aye.
Westland,
Aye.
Stigleader. Aye.
Motion passes. Thank you. Next item up is unfinished business, returning ordinances. We have several. The first is ordinance MVBC annexation.
I move to place the ordinance MVBC annexation file number ANNX-23-6 on its first and only reading by title only while under suspension of the rules.
Second.
Motion second. Discussion? Roll call, please.
Malloy,
Aye.
Ziegler,
Aye.
Westland,
Aye.
Stigleader. Abstain. Flu.
Aye.
Motion passes.
An ordinance of the City of Post Falls, a municipal corporation of the state of Idaho, annexing property consisting of approximately 3.60 acres located at the southeast corner of North Chase Road and East Prairie Avenue, providing for amendment of the official zoning map and providing for an effective date hereof.
I move to approve the ordinance MVBC annexation file number ANNX-23-6 and to direct the clerk to assign the appropriate number and that it be published by summary only.
Second.
Motion second, further discussion. Roll call, please.
Malloy,
Aye.
Ziegler,
Aye.
Westland,
Aye.
Stigleiter,
Abstain.
Blue,
Aye.
Motion passes. Thank you. Next item up tonight is ordinance Title 18 Frontage Improvement Code Amendment.
I move to place the ordinance Title 18 Frontage Improvement Code Amendment on its first and only reading by title only while under suspension of the rules.
Second.
Motion second, further discussion. Roll call, please.
Ziegler,
Aye.
Westland,
Aye.
Stigleiter,
Aye.
Blue,
Aye.
Malloy,
Aye.
Motion passes. Mr. Harrington.
An ordinance of the City of Post Falls, Kootenai County, a municipal corporation of the state of Idaho, providing for the repeal and adoption of Post Falls Municipal Code, Section 18.24.020.f, to provide right-of-way dedication and frontage improvement requirements, standards, and exceptions, providing that remaining sections of Post Falls City Code shall remain in effect, providing for severability, providing for this ordinance to be in full force and effect after its passage, approval, and publication according to law.
I move to approve the ordinance Title 18 Frontage Improvement Code Amendment and to direct the clerk to assign the appropriate number and that it be published by summary only.
Second.
Motion seconds, further discussion. Roll call, please.
Ziegler,
Aye.
Westland,
Aye.
Stigleiter,
Aye.
Blue,
Aye.
Malloy,
Aye.
Motion passes. Thank you. Next item up tonight is Public Works Operations Center.
Good evening, Mr. Mayor, members of the council. Andrew Arbini, Projects Division Manager. I am presenting a contract with Integris Architecture for the design of the Public Works Operations Center this evening. About 5 years ago, or over the past 5 years, John Beecham, the Public Works Director, has been leading the planning efforts for the Facilities Master Plan as well as the Public Works Operations Center. This request this evening is a culmination of those efforts. Have about a dozen slides to walk through just the background and where we've been over those past 5 years. At the end of the presentation, I anticipate some questions and discussion. I may call on John Beecham to facilitate any of those questions depending on the specificity. So to familiarize everyone with the location, this is the Public Works Operation Site located on future Hargraves Road. This is between Pleasant View and Corbin. This is really a roadmap of where we've been and where we intend to go. So the top row shows the last few years and working through the planning side of this, where we intend to go in the next 2 years with the start of design and eventually construction. As of now, these are planning level timeframes. A little bit of background. So the 2021 Facility Needs Assessment was a study of all the non-program facilities in the city. This identified future needs for each of those facilities. So this is a separate plan from a water master plan or a wastewater master plan. For the Public Works Department, there were improvements identified, and primarily this confirmed the need to relocate the streets, fleet, and water divisions from the water reclamation facility. By relocating those divisions in the long term allows the water reclamation facility to continue to expand on that site. Shortly after the completion of the facility plan, the city purchased 9.5 acres for the future development and construction of the Public Works operation site. This is the site located between Pleasant View and Corbin. In spring of 2024, a little over a year ago, the city consulted with Integris Architecture to develop a feasibility assessment for this project. Those findings were presented this past May, and ultimately what was concluded is that the construction is feasible, and the cost estimate for this phase one is $11.6 million. At that time, City Council gave staff direction to proceed with negotiating a design contract. This is a culmination of pictures of the streets division. This is the crew support facilities. You can see the first image is the restrooms on the outside, the support facilities on the interior, the break room, open area for meetings. So we are currently at capacity and have made additional means to accommodate staff. This contract with Integris tonight includes the design of the structures on that new parcel for the Public Works Operations Center, and it also includes the required site design, which includes the street and frontage improvements, water and utilities, and then the sewer and septic system. This is a preliminary concept. This was developed through the feasibility study. This will continue to be refined. This represents some initial staff input in putting together the spaces and what the minimum need would be in relocating staff and fleet or staff and other infrastructure out to the site. So we have a list of what is included and what is not included. And then, as I mentioned in the previous slide, we listed out what would be the minimums we would need to locate on that site. So in the left column really represents those minimum needs. We also have a list of what is not included at this time. I did want to highlight the top row, the fleet relocation. So that is not included, but we have asked Integris to include a final analysis of that in their design if there is an opportunity for fleet to locate at this time with this phase one. So currently we're not planning to relocate them, but we do want to give that another look. This is a summary of the breakdown of the funds. So the total estimated project cost is $11.7 million. This is really broken out proportionately for each of the funding, the different funds that are contributing to the project, and that's based on allocation of who's using that facility. So the total contract cost tonight is $757,792. That includes a 5% contingency, which we are requesting. I will show that on a future slide. So here's the summary, essentially the same thing that was in the table. Contract award is $721,707 with the 5% contingency. That brings it to the $757,000.
Does that 5% contingency come equally out of each of those funds?
Yes. Oh, I believe that this total was that 757 was then divided out between those three different funding sources.
Thank you.
So next steps, pending approval tonight for this contract, staff will have a design kickoff with the architect, begin the design process. We anticipate design through the rest of this year, looking to construct next spring. We'd start construction and expect about a year's worth of construction. With that, I will open it to any questions.
Questions, Vandrew?
Have we used Integris before? I don't know that I've heard that. Yeah, okay.
Yeah.
We have.
Yeah. Okay.
So I put it in the memo. I did not expand on that, so thank you for pointing that out. I did not mention it in the presentation. Integris was selected from the city's consultant roster.
Okay.
We have used Integris for the feasibility study for this project. I believe other city departments have also contracted with Integris for other projects. They are a local firm with a presence in Idaho and Spokane. I think primarily their offices are located in Spokane.
Okay.
Jeff, for some background too, for those that maybe in the audience that don't know, the current facilities by the water reclamation facility have to move because the water reclamation facility has to be expanded. So this isn't something new for the sake of it being new. We actually have to get rid of those facilities too, so this is a necessary thing.
Those facilities are currently renting space from the water reclamation intents and purposes.
I move to approve the design contract for the Public Works Operations Center.
Second.
Motion second, further discussion. Roll call, please.
Westland,
Aye.
Stigleader,
Aye.
Flu,
Aye.
Malloy,
Aye.
Ziegler,
Aye.
Motion passes. Thank you. Thanks, Andrew. Next item up is the Water Reclamation Facility Tertiary Treatment Improvements, Contract Amendment with Panhandle Area Council.
I'm back. Almost closed up and walked away. Andrew Arbini, Projects Division Manager. So this item tonight is a contract amendment with Panhandle Area Council for the Water Reclamation Facility Tertiary Treatment Improvements. So the last time I was here, I think last February, for a similar request, also provided an update of where we were at the time on the project. At that time, we had just started the startup of the membrane filtration system. We were in the early stages. I can report, on a positive note, we have started up all of the equipment, and we are operating the facility and treating wastewater. There are some items that remain outstanding, and those items are required in order to meet substantial completion. So a recap of those items, we are missing a final report for the membrane system. That's a final acceptance testing report. So the system is operating, but that is a contractual item that is owed by the contractor to the city. We also have a claim that is outstanding for additional time related to some HVAC work, and then we are working through some warranty discrepancies on the project. This would be warranties for the project and various equipment throughout the improvement project. So coming back to Panhandle Area Council, PAC's role is to provide prevailing wage services and monitoring of the contract. This contract involves state revolving funds, and as a requirement of that, the city is required to ensure that prevailing wage is actually being followed. The prevailing wage requirement is required all the way through substantial completion. Since the contractor has not yet met that, we need to continue those services, or staff is requesting that we continue those services through the substantial completion. So the request tonight is an additional $2,000. This would be time and material not to exceed, bringing the revised contract total to $119,957. This would be funded through the project GL code listed on the screen. And then just to confirm, the funding sources do remain aligned with the master plan financial strategy. So the next steps, continue to work towards the substantial completion of the project, which includes final acceptance of the membrane system, and then working through the contractual documentation and contractual remedies with the construction contractor. So with that, I will open it to any questions that you may have.
So this is a couple $1,000s more, and because we have not received the final report yet back from the contractor, and I know we've got some negotiations going on as far as liquidated damages, et cetera. Is this $2,000 anything we can recover from the contractor?
So the liquidated damages that you mentioned is the tool in our contract, with the city's contract with the contractor. It contemplates the assessment of liquidated damages, and that is really intended to account for the actual harm that the city faces for late delivery. As we're working through the remainder of these contract items, that is still in discussion.
Yeah.
The city has been contemplating the assessment of LDs as we've received payment requests from the contractor. So there, in a not direct way, there is a pathway through the city's construction contract through LDs.
I get $2,000 in light of a $40-some million contract, so not huge, but I thought I'd ask.
I'm sorry, why is it only 2,000, not the total 120,000?
It was an amendment, right?
Correct. It was an amendment
Oh,
to
to-
the contract. Let me back
Just
up.
an amendment.
Oh, I'm sorry, the revised contract total. Okay.
So the,
Sorry, thank you.
yeah, the $2,000 is the adjusted amount, so
Extended
additional
time.
$2,000.
Already approved to the 117.
Correct.
Thank you.
Any other questions?
Yeah, I would like to see us be able to recoup that damage. I mean, I know it's, $2,000 is $2,000, so.
Yeah, so to date, the city has not waived any of its contractual rights in our contract with the general contractor. I mentioned that there is an outstanding claim that we are working on with the contractor that is for some additional time request related to some HVAC components. The current unmet substantial completion date in the contract is November 20th, 2024. So as we work through that claim, if there are any additional days added to the contract, that would be reviewed against the substantial completion date and, as I mentioned, our assessment of any liquidated damages.
Okay.
That really is the sole recourse for recouping any damages or financial harm to the city.
Thank you. Entertain a motion.
I move to approve the WRF Tertiary Treatment Improvements Contract Amendment with Panhandle Area Council.
Second.
Motion second, further discussion? Roll call, please.
Stigliter,
Aye.
Clue,
Aye.
Loy,
Aye.
Ziegler,
Aye.
Westland,
Aye.
Motion passes. Thank you. Thanks, Andrew. Next item up tonight is the Prairie Trail Zorros to State Highway 41 Additional Service Amendment Number 1. Mr. Paulus.
Good evening, Honorable Mayor, members of the council, Robert Paulus, City Engineer. So tonight, engineering staff is asking for your approval to enter into an amendment number 1 with Welsh Comer and Associates for professional services associated with the state highway, the Prairie Trail between Zorros Road and State Highway 41. Doesn't want to do that for me. Better. The cost of the additional work would be $24,500, and that is for geotechnical services during the portion of the project that would be filling the borrow pit. So back in March of 2005 of this year, we hired Welsh Comer and Associates at $80,000 to go through, do a geotechnical analysis as to what it'd take to fill that pit, make sure that it'd be safe and able to handle the construction of a trail and what type of methodology would be needed to compact that fill as it was put in. With the professional services agreement, we did not include geotechnical inspections for the construction phase. Typically, we would include that type of stuff as a requirement of the contractor to hire a third party to do that. When we got to May of this year, we were proceeding with going out for bids for the project, and we did not include the geotechnical services in the contract for the contractor to provide. There was some benefit to us in that with the complexities out there and wanting to have a little bit more control over what was going on with the fill and oversight of that, having the same geotechnical engineer under Welsh Comer as who had done the original design was to our advantage, in our opinion. The original estimated construction cost for this project is $368,925. In June of this year, we awarded a contract for that construction at $175,225.50. And it did not include any geotechnical inspection in that. So an overview of our professional services, that $80,000, about half of that was for design services, a small portion, about $6,500 for bidding, and then there's an hourly not to exceed amount of $24,400 for construction. That's Welsh Comer's costs to be out there and to provide certification for the asphalt path and some of the other work. But the actual testing of the pit, that's where we're asking for the $24,500. In terms of construction, we are at that $175 to $25.50. That is the contractor's cost plus a contingency amount in there. So tonight I'm asking for approval to enter into amendment number 1 with Welsh Comer and Associates for $24,500. stand for any questions you might have.
Still, the projections come in significantly under the engineer's estimate.
The construction cost did come in about 50% of what the engineer's estimate was, yes. In one way, you could take a look at this in that the geotechnical services, instead of paying the contractor for it, in this case, we're paying our consultant, and that dollar was just moving from one spot to another.
Thank you. Any questions, Rob?
So I know that the original contract amount was significantly less than what was estimated, but do you find that it was reflective of not having the geotechnical inspection in it? So essentially, I'm asking, are we paying twice for this service that we didn't put in the contract the first time?
I don't think we're paying twice for this service.
Right, so if the first contract, we just didn't put it in, is it like reflective of that like lower price point? Does that make sense?
Is
What
that
I'm
making up
asking.
the difference? Is that what you're saying?
Yeah, or like was
I think it's
it-
on the previous slide, if you go back.
Well, so would you, at the price of $175,000, would you have expected that geotechnical inspection to be in that contract at that price?
I would have expected, had we put the geotechnical inspection in the original contract bids, that the contract prices would have been higher.
Okay, that's my question.
And that the 24,000, now professional engineering services are based upon qualifications, especially when we go out and do that. A contractor can request, even though professionally they, engineer should not do that, should not provide quotes. They should provide, based upon the services being needed to be rendered, here's what the cost is. But in general, I would have expected that all of the costs from all of the contractors who applied would have been higher because they would have been trying to hire a geotechnical, and I would have expected something around that $20,000 to $30,000 range.
Okay, that's my question. Thank you.
Thank you. Any other questions?
The geotechnical inspection, is that a result of the damages that were made to that pit?
Because of the size of that pit, and the fact that we want to have a multi-use trail next to it, we want to make sure that it's built up in such a way that we can still utilize that as parklands, and that trail, after we construct it, will not start to settle or cause potential damage to the adjoining property.
But are any of the damages that we settled with, will they be, are we recouping any of our costs to this geotechnical inspection from the
So
settlement?
with the settlement, we would be utilizing that to help pay for this. We are paying for this out of the multimodal impact fees, but we are reimbursing the multimodal impact fees from the settlement that we received.
Okay. Right. Gotcha.
Phil, I'm not sure if you can hear you, but we can't, so
My mic, oh, there it goes.
there it goes. Okay.
Those damages claims were settled as part of the settlement.
Right, no, because it was not listed as a source of project funding, I was unclear on that, so.
Gotcha.
Any questions? Entertain a motion.
I would move to approve the Prairie Trail Zorros to State Highway 41 Additional Services Amendment Number 1.
Second.
Motion second, further discussion. Roll call, please. Thanks, Rob.
Blue,
Aye.
Malloy,
Aye.
Ziegler,
Aye.
Westland,
Aye.
Stigliter,
Aye.
Motion passes. And we're okay on the next item?
Yeah, just a quick note, it was listed on the agenda as fiscal year 2026 budget resolution. It doesn't actually require a resolution, it's just the budget estimate that then gets published in the paper, so.
Which is a high water mark, correct?
It's the high water mark, correct?
Okay. Jason?
Good evening, Mayor and Council. Yeah, that was something that Warren and I were discussing, if it was an actual resolution, but it's not. The proposal that I have before you shows the actuals from 2024, the budget for 2025, and the proposed budget for 26. This is the highest watermark for the budget that we'll bring back to council. The next public hearing will be the actual budget itself, and this is just strictly to get the advertising started. So it's not tying council to anything. This is just for telling everybody we're having a budget hearing on August 19th, and here's what the preliminary budget is, and then this is the highest part of it, so.
Which is to say that legally, whatever number we put in this high water mark, we could not approve a budget higher than that when we
Correct.
come to our actual vote, which is why we take the highest possible amount at this stage of the
Right,
budget.
because if we come back later on, they compared what I advertised versus what council approves, and they'll stick to what we advertised on,
We
so.
can still do something lower.
We could
than
still do
this
something
number.
lower, that's right, yeah.
I would move to approve the fiscal year 2026 budget publication. Is that the right word?
Just, yeah, budget estimate would be.
Estimate, okay.
Motion second? Further discussion?
Who did the second?
Nathan?
Malloy,
Aye.
Ziegler,
Aye.
Westland,
Aye.
Stigleader,
Aye.
Flu.
Aye.
Motion passes. Thank you. Next item up is new business, and it's a memorandum of understanding with Post Falls School District number 273. Mr. Fair.
That's a great picture, Mr. I feel like that's what parenting feels like right there. Stay still.
No, because those kids are paying attention.
Oh, well, then.
Doesn't feel like parenting.
You can see I'm slower than my staff because I don't get to come up and talk to you guys too much anymore. Dave Fair, Parks and Recreation Director, Mayor, members of the council. Tonight, I'm bringing you an updated version of an agreement with the Post Falls School District. This isn't the first one we've had. The first one was in 1999. We called it an interlocal agreement. And that really just formalized how we operated together, what the expectations were, priorities. It just formalized a very informal system. It was updated again in 2010 because there were changes in operation, changes in staffing. And then this last year, what you see before you is a memorandum of understanding, and that was at the request of the school district. They came to the city about a year and a half ago, and in that time, we've been discussing it back and forth. So staff, legal staff on both city and school district, and then legal departments on both sides. So it's taken time to get there. I tried to give you a summary of what the agreement is, the major portions, the priority use structure really doesn't change from what the interlocal was to the MOU. Maintenance and cleaning responsibilities, there are things that were happening and not happening on both sides, so we tried to clarify that. Cost sharing, it did formalize bringing in cost sharing as a part of it. Supervision requirements, really no change. It's been there. Damage and liability really didn't change at all. And then annual review did not change.
So the cost sharing was the change?
That was formalized. So the two major changes to this version is scheduling of the gyms to outside groups. We took that on because some of the school principals would do it, some wouldn't. They didn't have consistency, so administration had asked us to do it. Before COVID hit, we were doing a lot of it, but it's tailored back and we're using more and more space. So we don't really rent that much. So the school district would like to have that control back, and we're more than happy to see that. The cost sharing, we didn't have a formal agreement, but we have shared in the past. It's probably been 10 years since we last did it. We would share on refurbishing some of the gyms. 10 years ago, it was probably about $2,000, maybe $3,000 each to do a gym. I can't tell you what the costs are now. We also paid for half of the tennis courts at the high school. We've bought the scoreboards that are in the gymnasiums at the elementary schools. There's been other things, so we've done it on a case-by-case basis. The school district just wanted to see that done on a more consistent basis, and part of that is because of changes within their staffing. Their business office has changed several times, so that's what was put in there. That's probably what also took the longest time in going through this, was just a difference in wording and trying to get that clarification.
Is there any verbiage within the MOU about that cost sharing that would give the city of Post Falls the ability to decline to do that at that time? Or is it totally within the school district to demand that money at whatever time they see fit?
The school district has to give us proper notice so that we can budget for it.
Okay.
Okay, so there's that part of it. And for myself, the unknown is tough, but then if we say we're going to give you X amount, but they don't do it. We did reduce the number of elementary or middle schools, so they can do up to, but we have to be able to budget for it. So it has to come back to you folks. Also, as a staff, we've discussed it. We will look and monitor what it costs us to do this maintenance, and we will also review through the hours we're using what the cost is to rent it. So at some point, we may say, you know, it's more cost effective for us to rent this than to have this MOU. I don't think so.
Okay.
They're not going to go out and refurbish the gym floor every year. At least they haven't done it in the past.
Okay.
So those are some of the protections. You know, just like on some of our facilities, we tried to outline each side of it.
So my understanding is that they get the first, first pass at parks. Has there been, I mean, I know a park is very different than a building and the resources used are very different, but has there been anything that we need to be considering of our resources that they utilize when they use our parks that we're not recouping in this?
We talked about it.
Okay.
I think on that basis, if we felt it was really a school district item, that was, we would approach them on a case-by-case basis. Probably the one thing is, say, the tennis courts at White Pine. They use them heavily for their spring programs, and they do their league play there. So maybe at some point, when we resurface, we may want to approach them and say, yes, you know, here's one of the things. You get to, like Kiwanis Park, what they do, the cross-country, really doesn't have that big of impact. So I think we don't have the facilities that they have. So there's that thing. At some point, the city needs to consider building a field house, 3 to 4 gymnasiums, so that we're not dependent on just one provider. On the same note, you get to something like that, and the school district may want to use it, and then you could come back in.
With a pool, right? That's what you were
Oh,
thinking?
pool.
Yeah. Okay. Thank you so much.
We've been
That
down
will
that.
be, mind you, that's after I'm gone, so then I
okay,
won't
okay.
be the sticking point on that.
I remember that discussion. It's been a good relationship with the school district.
It
I'm going
has.
to date myself, but I was around when that first memorandum, MOU went into effect. And the school district, you know, there've been some quirks maybe along the way, but it's, the sides have been able to work it out, and I think it's been beneficial to all of our citizens, so.
Well, and as Mayor Jacobson likes to throw out a little bit of trivia about how long he's been around on some of these things and doing that, but that interlocal agreement actually came from the first city I ever worked at, which was Mount Lake Terrace. It ended up going to Federal Way with our director when he went there, who worked with Dick Harris on creating it. So in a roundabout way, you know, I've got 43 years coming back.
Yeah. Dick Harris, former superintendent of Post Falls, so I mentioned. Phil.
I also wanted to address your question on there is a non-appropriations clause in there. There's also some cost control measures as far as if it exceeds a certain amount, we come to the table and talk about it, as well as a annual meeting to get together and talk about what we're doing. And just the function of it being an MOU rather than like a joint powers agreement or something like that. MOUs are just a little bit more flexible to say, you know what, we really don't want to do this anymore.
Okay. Thank
Yep.
you.
Any questions or further questions, comments?
I would move to approve the memorandum of understanding with Post Falls School District Number 273.
Second.
Motion second, further discussion. Roll call, please.
Ziegler,
Aye.
Westland,
Aye.
Stigleiter,
Aye.
Blue,
Aye.
Malloy.
Aye.
Motion passes. Thank you.
Thank you.
Thanks, Dave. Next item up tonight is citizens' issues, and anyone in the audience who wishes to address the city on a city-related issue that is not on the agenda, we'll let you come forward, give your name, and there is a timer. Is there a timer on the
Yep.
Diaz?
There is a timer.
And again,
on-
folks, we want to listen to you. All I'd say is, I think we're pretty much, everyone's going to say the same type of thing, which is fine. Let's try not to repeat, get your points across, and we'll go accordingly. Come on forward, sir. And as you get up here, please name for the record.
Mayor, council, thank you. My name's Rob Dorsey. My parents own the property that we're discussing tonight. They've lived in this town. My mom graduated here, I graduated here, our kids graduated here, we have roots here. They bought this property around 20 years ago and lived on it ever since. They're replacing a double wide, an aging double wide with stairs to, it's a 3-bedroom, 2-bath, and would like to replace that with a 3-bedroom, 2-bath stick-built house that's a little more conducive to aging and remaining in their home. I live in the city of Post Falls, that neighbors their property, so I chose to live there so that in the future I'm close to taking care of that. We applied for the permits to the county, and they are mostly approved. They have a existing approved septic on the property that's approved now through the permitting process. The city of Post Falls has blocked the permitting process and is forcing us to annex into the city. And we don't want to annex into the city, and that's the debate. That's the issue, is they chose to live in the county 20-some years ago, and they would like to remain in the county. We've had meetings, and their consent for annex at a future date is still forced annexation. It's just the future. That was still annexing into the city. So either way, one was absolutely going to annex into the city. The other one is a future date. And either way, it's annexing into the city. They want to remain into the county. Also give up the right-of-way in the process and not compensate for that, which I understand is a different issue, but that is part of this issue. They lay their argument on an area of city impact, the ACI agreement. It's an agreement between the city and the county. I believe that when this document was, it's a 2004 document, and it was designed to move our county and our cities forward into the Rathdrum Prairie. It talks about subdivisions and subdividing. We're not subdividing, and we're not creating a subdivision. At a later date, if we chose to subdivide that property or divide or subdivide or make into a subdivision, at that time, I would see it appropriate to apply to be annexed into the city of Post Falls, and of course, adhere to the rules that are current at that time. At this time, I don't believe that's necessary. I think they should be able to remain into the county and not be forced to annex into the city. And that's our statement.
Okay, so your point is, and again, I think as we mentioned earlier, staff has visited with you, I believe, correct?
Correct.
And so your concern now is annexation now versus later?
Yeah, the first meeting said that annexing has to happen, and there's no appeal to that.
Okay.
So what we say is just how it is. Our last meeting said, well, we can defer, or their words are consent for annex at a future date, which is still annexing into the city. So we can't define future.
Can we?
It could be any time. Go ahead.
Is it all right if I ask questions? Sure. If we were to do that, because based on discussions we had earlier, I think we're trying to find a way to work with you on this. If we say it would be contingent or annexation in the future, could that be contingent on subdivision? Are there certain things that would kick that off? Or
So we would, what it is, and I think what he's alluding to is basically a consent to annexation agreement. We can't do a normal development agreement because, again, they're in the county and we're the city. So we can't do a normal sort of development agreement. But the consent to annex agreement would be akin to negotiating some of those terms as to when those things would occur and what things we can time appropriately, but that.
so if
that
it's a
could be
consent
discussion.
to annexation based on a subdivision, I mean, can you put a requirement or a time frame on that? Or do you have to leave it open-ended?
Maybe.
So I go back to your point, as you said, if we want to subdivide this in the future, you said it would make sense to then apply to the city and have it annexed in for wastewater, et cetera.
Yes.
So that's my question, if we could tie it to that.
I think we could explore some of those terms to say further development or adjacent development or some of those type of things. But that's
My
something
point is,
that
we understand where you're coming from. We truly do. We also understand that as properties are developed within the area, even if a county pocket, we want brought up to code. But if you're not being forced to hook up to sewer, which is very expensive, if you're not being forced to annex at this point, and if we could put some kind of guardrails on it that says, in the future, if you want to develop it, this is what we're going to need. I'm just wondering if that's a possible solution.
It may be. I think that's something we would, further meetings are needed.
Okay.
And that's what I propose, is that in the future, if it does get subdivided or developed, that at that time you go through
Sure.
the annexation process and we appeal to the city at that time. But right now, we would choose to remain in this,
Right,
into the county.
and I think from what I'm hearing is we're not gonna force you to annex, now versus later, but I mean, if they wanted to build a house now, they're not gonna be forced to annex, they're not gonna be forced to hook up to the sewer. I think frontage improvements, some of them could be waived or deferred as well. So my point is, I think we're trying to get where you're trying to get, but it's just how we do it is my questions.
As long as we leave annexation out of it, then we're really just dealing with the county is my understanding, because the city would have no say in it if it's
And
not
I'm
in
just
the city.
wondering, and the reason I'm asking the questions is based on our current ordinances, whether or not that's doable.
There would need to be some sort of agreement in place because we are dealing with set ordinances. That we have laws on the books.
Yeah, that's
that-
the
that-
slippery slope, yeah. Warren, you have something?
I was just going to say that ultimately, whatever we work out, if we can work something out, needs to go back to the county because this is a county requirement that requires them to meet city infrastructure standards in the area of city impact. So normally how this works, the county gets an application, they forward that to the city and say, we've got an application, what's the standard that they need to comply with? We provide that. And the county says, look, that's your requirement to comply with this because that is their development code. So odds are the county is going to be completely fine with if we work out a scenario, but I don't want to say that that's a foregone conclusion because we'll have to check in with the county. The odds are it's going to be completely fine, but this is their standard, not our standard.
So, I think, if I can summarize, and correct me if I'm wrong, we will continue to work with you, try to find a way to resolve this. As Mr. Wilson just said, we do have to go back to the county on this. And, if there's a time, if there's an opportunity to say annexation at a future date based on certain items, i.e. subdivision, again, I don't know what's legal. I've got to defer to our legal counsel. But my point is, I think we're trying to get to the same point you're trying to get to.
Yeah. And meanwhile, my parents are living in an RV on their property in the county, so it's inconvenient as we slow the process down. Just want to add that.
I might comment a little bit on this. To me, listening to your testimony and kind of also the city's position in relationship to the county, I think the kind of where we're getting tripped up is, in my mind, that the definition of development. It sounds like you're very reasonable in your understanding if this was a parcel that you had intended on developing into multiple parcels or even twice as many as there is now, and I agree with you on that point of it would seem reasonable at that time that you would be required to be annexed into the city to meet those codes. I don't think in a normal interpretation that updating a existing structure to one that is almost exactly the same would fall under the definition of development. So my suggestion would be then for us, even if we need to work with the county to rewrite the ordinance to somehow add some more definitive language into what development means, that would then trigger the requirement for annexation.
I agree. That's doing something for someone.
Right.
Yes.
So then it would be much more clear of saying, okay,
Yes.
I have a property that's in the county, even if it's surrounded by city. If I do this, then I will be required to do this. If I don't, then I'm not. I think it's just a very ambiguous definition of what development means.
Mm-hmm.
We need some guardrails. Anybody else?
A question that I had that hasn't been able to be answered terribly readily is, okay, if constructing anything qualifies as development, then what if somebody who's in the exclusive tier of the area of city impact has a structure and that structure burns down? And all they want to do is rebuild it exactly like it was. They're then required to annex into the city? To me, that seems kind of weird.
I've been asked the same question. It's like, well, what if their house burned down? Then what would have happened? And
Too late for that
I
now.
don't know that, but that is a good question because these things, what are the odds that I would be standing in front of the city council talking about something like this? Because I don't believe that this was designed to do that.
Right.
I really don't.
Samantha?
I have questions about how this was presented to city council when we approved the area of impact very recently, so I don't know if I should address staff about those now or if you'd like me to wait until council comments.
Well, actually, it was back in 2016 when this started, right?
Yeah, the area of city impact has been in place for longer than.
Sure, but we had many discussions about the area of city impact recently when we approved the most
So we had
recent map.
conversations about the boundary and shrinking that boundary.
Right, but I think
We haven't
during-
really talked about what the standards are.
I think that during those conversations, though, we did ask about whether or not that meant that those areas had to be annexed or had the intention of being annexed. And so what it seems like, based on the situation that you're walking through, that I'm very sorry for, that when it was presented as this is just something that the state mandates that we do, and we have to fill this land with either our color or Hayden's color or Rathdrum's color, it's just a state mandate that we have this area of city impact, and that it wouldn't affect that what landowners are doing in the county unless they wanted to annex into the city. But it seems that maybe it is pressuring them a little bit more, and I'm a little bit concerned about the fact that this is happening and where it might happen again. And I mean, you guys are a city or an island within the city, so I think that that's slightly more unique. But what does that mean when we're talking about places that are right on the boundary of Post Falls? Then are they also forced to annex because perhaps they have sewer that is available?
They want
if they
sewer, they
wanted
would
to
have to
develop?
be, right? We don't provide sewer outside the city, but if they're on a septic that's acceptable and approved by Panhandle Area Council, or who is it?
District.
Health District, thank you. We talked about Panhandle Area Council earlier. Panhandle Health, yeah, they wouldn't be forced to annex in.
Then why are they why is the forced
County.
annexation? So is the county gonna force all people to then annex?
County.
into
So
the-
maybe we should set this up for a workshop or
Yeah,
a discussion
okay.
later. I think we're confusing. The city always has the opportunity to annex something or not. Your
Yeah.
decision to annex a property is entirely up to you. We have existing agreements with the county that the version that is currently in place, there's a version before that. This is decades old, essentially, of the former statute dealing with areas of city impact said in the agreement you have to specify whose rules and what those rules are going to be in that area of city impact, which essentially turned into, because city ordinances don't have impact outside of city boundaries, they have to become county ordinances. And so what it becomes is the county needs to adopt for the areas of impact or areas of city impact, a set of rules that are going to govern development. And they're typically based, and this is true across the state, typically based on the city standards, so that when those areas annex, they can tie in and mesh in with the existing city-built environment around them for sewer, water, roads, those types of things, sometimes lot configuration, whatever that looks like. We try to work on these things as they come in on a case-by-case basis. We don't get a ton of these, but we do have some. And we do occasionally do a consent to annexation agreement, wherein we essentially say, you don't have to come in today, but you'd need to either stub out a dry line sewer so it's available when sewer reaches your property. You can do what you're going to do. And so we deal with them largely on a case-by-case basis to try to figure out how do we best effectuate the goal of making sure that the development that happens fits in with city services around it, as well as making sure ultimately that they come off of septic, because that's over all of our drinking water. And then finally, also trying to get equity to make sure that people who are using public services are paying for those services.
What if you wanted to annex based on what the county told you, and then the city council said no?
We'd figure it out. It would be an interesting conundrum. I don't know that that's ever happened, but we would figure it out.
My concern is that the area of impact was at least presented to the council presently as being something that the state required that we have. And I do remember that we asked as a body, this isn't signaling that these are areas that we have intention to annex, and this isn't requiring that the city do anything on these people's property or that we force, and my understanding of those conversations was that the area of impact didn't impact county people doing county business, but it seems like perhaps it does, and that's what I'm concerned about.
So I think that you're remembering that incorrectly, because the statute changed about a year and a half ago.
Okay.
And so we're negotiating new boundaries and new agreements as we speak. And the prior statute that sunset in December 31st of this year essentially allowed areas of city impact to include not just growth areas, but trade areas, areas that you had impact on so across the river. We're never going to likely annex across the river, but growth over there has impact on the city because of traffic coming across the bridge. We could include that in our area of city impact under the previous statute. Under the new statute, the only areas that it can be included are areas for growth, for annexation. That's the only standard. That doesn't mean that the city in turn has to annex that property, but that's the merit. That's how you measure that new boundary is this an area that could be annexed within 5 years? That's the only standard. So it really is going forward, starting January 1 of 26, that will be the only standard that applies in determining an area of impact. Excuse me.
But regardless, when someone tries to develop, the county has the ability to dictate and mandate to them that they must develop in the same way that the city would mandate it.
Yes.
So that's my concern when we draw these areas of impact, is that it then triggers these landowners to have to abide by our rules, which is exactly what's happening.
Yes, the caveat, I guess the nuance I would say is, just like the city has the authority to adopt ordinances regulating how things develop in the city, the county has that same authority in the county. Here they're just saying, for this area, our zoning code is going to mirror the city's zoning code. That's kind of what it turns into. It is not a city standard, it is a county standard.
So our approval of the areas of impact is not what triggered this to happen. It is the county that needs to revise their requirements for what happens with land that is technically in the county, but has been identified in Post Falls as an area of impact.
Yeah, our ordinances don't have any impact or effect outside city limits. So it's a county ordinance that's being applied.
And
the county ordinance just happens to be based on our standards.
And the county sets the ACI boundary as well.
Okay, so then maybe my thought process through all of that, thank you for being patient with me, is then that for anyone that is upset by the situation that you find yourself in, which seems totally reasonable, it is also your local county government that needs to understand the risk and the responsibility that they're putting on landowners that are in the county and requiring them to do that. So it's nice for us to be able to hear what you're going through, but also maybe perhaps what is dictating this issue more is really the county government. I don't want to say county commissioners, because Gil will probably get me in trouble if I use too specific of words, but the local county government as well. So I don't know, hopefully that information was helpful to other people as well.
But hopefully, you see, we will try to work with you on this, and we will try not to drag it on, but try to find a resolution for you. And again, the big thing to me was, and we'll let others talk, is we're not forcing you at this point, to hook up to sewer, to annex improvements, et cetera. So we'll do what we can do. Anybody else have comments?
Yeah, I just want to echo the recommendation to refer this to a workshop. I think in this particular case, we have goodwill on both parties to keep working toward this solution. Obviously, I haven't been part of the conversation, so I hope that can be worked out. But as a kind of an example of the broader policy, there's obviously a lot of homeowners in the county that are affected by this, and I think this is something that obviously the citizens don't understand well, the council doesn't understand well, and we should have a workshop to go through the details of this to make sure that whatever regulations are in place and whatever our role in it is still serving everybody's interests. So I would just like to kind of get that on the books and then make sure we dig into this if there are any issues long-term, we should sort those out.
Okay.
Excellent. Any questions for me?
Thanks
All
for
right.
taking the time.
Thank you.
Anyone else? Did you get that timer working, Field?
I think, the TV keeps turning off on me. I do have the timer. I'll just have to signal you because I don't know why that keeps turning off.
Thank you, City Council. Larry Spencer. So I've been involved a little bit with this Area of City Impact Ordinance of Post Falls number 1049, good 15 years now. One of the authors of it was Sherry Howell, who called it the unholy agreement when I asked why it hadn't been renegotiated within the few years that it was envisioned and stated that it was supposed to be renegotiated. But I would like to address a couple of misunderstandings. First of all, I spoke with David Callahan, who's the community director of community development director of Coeur d'Alene, or sorry, of Kootenai County, and he was surprised, to say the least, that the city was now taking the position that development meant building permits and not subdivision developments. As a former legislative advisor, we have a saying in Boise that words have meanings, and they really do in this. If you read through Post Falls Ordinance 1049, it talks quite a bit about different development, but only in subdivision and infrastructure development. Nothing in this document was ever, if you read the document in its entirety, nothing in the document was indicating development of a property. It was talking about subdivision and infrastructure development, and it specifically calls out those two, and I would say that that's exclusionary. It didn't anticipate it. As a matter of fact, some of the representations of staff, and with the best of intentions, I think that staff is looking at this from a direction that doesn't really work. If you turn to page 4 in this, there's a glaring problem in that under applicable regulations within the area of city impact, number 4 in the exclusive tier says that the county agrees to require all development to use public sewer and public water systems. That hasn't happened in the last 21 years, and the reason for that is because they're talking about subdivision and infrastructure development. They're not talking about a house, which is why this thing has never come up before. David Callahan was very surprised to find that staff was taking the position now that this was going to apply to a home. That wasn't the intent of it. If you read through it, it's very clear that, matter of fact, in A it says, the only place it talks about this is, or not the only place, but number 5 on page 4A, exclusive tier, it says, the county agrees to apply infrastructure and subdivision development standards identical to those of the respective cities for all development within the exclusive tier of area of city impact. And that was because you don't want the county not requiring sidewalk, allowing a 20-foot wide private driveway to serve 4 residences. You don't want that to happen in something that's going to end up getting annexed into the city. That's what this document was designed to protect against. It was never designed or envisioned, if you read through it, there's just nothing that would indicate that it was about a home or development of a single property existing like this. The other thing is, again, it states right in here that it would have to be hooked up to sewer, and per what the mayor said, you can't hook up to sewer without annexing. If the intent of this was the development meant a site development of a home, they would just say, no development building permits will be issued without annexation into the city. That's not what the plan was. So I think that, and I agree that the city of Post Falls and the legal definition of the word development means pretty much everything, bigger than a treehouse. But that's not the spirit and the intent of the way that this was written. This wasn't written using it that way. And the only time that, I mean, they didn't think to call it out and say that the term development does not mean an individual home, but they did call out what type of development, and it was just subdivision and infrastructure development. And so I think that the easiest and the best solution in this would be to go back to the historical, because there has been other properties that have been developed, and this has never been an issue. Lots of them over the last 21 years. Nobody has ever, to my knowledge, nobody has applied this standard. At least if it has, it hasn't been consistent, because I can go and look at other properties that I know of that were built in the last 10 years, and they don't have, there was no dedication of right-of-ways, there was no 10 seconds. Okay. So if there's any questions, I'd be happy to answer any.
Thank you, sir. See none. Anyone else?
Mr. Mayor, City Council, I'm Lloyd Dorsey. I live at 2595 East 12th. I live there with my wife, Virginia. I'm 79, she isn't.
Smart man, smart man.
What started this was a double-wide, 3-bedroom, 2-bath trailer, 2 porches, 5 steps up and down. We're not getting any younger. We're trying to look at places that we can help ourselves in the future. We've decided that the best thing we could do is to build a house, replace the double wide. So we went to an architect, got a plan, submitted for the county. Everything's looking good, and all of a sudden Post Falls says, no, you're not doing nothing. Unless you do what I tell you, you're not doing nothing. If you want to know, that felt like extortion to me. I've got your permit and you ain't doing nothing unless I okay it. Do what I tell you and you'll get it. That was what I got. The city seems to me like they're using that ordinance way more than what it was intended. I'm not very doing this, so I have to.
You're doing fine.
Kind of have to take my time. The house replacement does not add any other burden to the city. I don't want any more service. Actually, the city supplies me no service. I don't get anything from the city on that property. So I don't need any more, there's no burden to the city from what I'm trying to do. All we want to do is replace a 3-bedroom, 2-bath with a 3-bed, 2-bath on the same footprint. And so far, no luck. I understand that there's a law that was passed last year that unless you're going to subdivide, that you're not in that area of city impact anymore. I haven't read it, I don't know for sure, but I will look at it. That's all we want to do is try to help ourselves for the future. We're not having much luck. And that's, yeah, I don't think that Post Falls document was intended to forced annexation. And that's what I feel. Forced annexation. I don't want it. I don't need it.
We're going to try to figure out a way for you to get it done.
And I'd appreciate that.
All right.
Thank you for your time.
You did fine. Anyone else? Well, thank you all for showing up. It's not too often we get a crowd like this, and it's either going to be really good or really bad. And that's why whenever I see a crowd like this, I always say, remember, because oftentimes there's going to be both sides of the aisle, if you will. And people aren't going to like what someone says, and they're going to be calling out. So thank you for behaving in an appropriate manner, and thank you for taking the time to show up and show your support. And as you've heard, I think the city is willing to work to try to help you accomplish what you're trying to accomplish. Next up, administrative staff reports. Fleet update. Mr. Beecham.
Working on it. Good evening, Mr. Mayor, members of the council. I have a short update on the state of our city fleet for you. I'm not asking for anything tonight, just wanted to give you an update on some of the numbers where things sit. Our fleet program has 5 full-time employees. We wish we had 5 full-time employees. We have 4, so if you know of a good mechanic who'd like to work with us, give us a call. We have 530 units. When we say units, that's not entirely vehicles. A sander that goes in the back of a dump truck is tracked separately than the dump truck itself, so those count as 2. This says 411 general fund. That's vehicles serviced by our general fund fleet. That does include our enterprise vehicles, which are serviced in the interfund transfer arrangement. So, there's almost 200 police vehicles, and the total value of all of those is just a little bit north of $19 million. That's an approximate replacement value. If we had to replace every single one of them today, that's about what we estimate it would cost.
And that includes the non-vehicle items that you're
That includes
tracking,
all
right?
of the units, yes. So sanders to snowplows to lawnmowers, big lawnmowers.
Okay.
John, does that include the leased vehicles? Do we have any leased anymore?
I do not believe we have any leased vehicles at this time, and it would not include them if we did.
Okay.
So, to take a second on lawnmowers, most of the small mowers are managed by the Parks Division. We do track a few of the larger mowers in our replacement program. The general fleet, so that's the non-police fleet, averages almost $400 per year in maintenance costs, and the average age of those vehicles is about 10 years. I keep saying vehicles, I should say units. The average age of a piece of equipment is 10 years. And police, it's slightly more per vehicle per year, and the average age is slightly less. And that's our fleet crew there right now, so they'd be great to work with if somebody's a mechanic and wants to come work with us. In terms of our replacement program, we've been building a more and more formal program over the last 3 years. We budget for that based on the useful life of the vehicles. So we estimate that a pickup will last 7 years, for example. That is how we make our budgeting projections. When it comes time to actually replace that pickup, we look at the condition of it and we say this thing can serve us well for another 2 years, or it cannot and should have been retired a year earlier, that kind of thing. We do take into account how things are being used, if they can be used somewhere else in the fleet, and if they no longer serve our purpose, even if it is earlier in the cycle, we might look at doing something different. In terms of replacements for this year, we have about $12 million in a replacement fund. Our authorized budget for replacing vehicles this year was about $2.5 million. We are on the tail end of bringing our dump truck fleet up to modern era, so that number should be going down into the future. The estimated need to replace all of the vehicles on their expiration date, so budgeting numbers, would be $2.9 million. And one thing I do want to highlight, we did utilize the contribution that would have gone into that future savings account this year, and we bought some vehicles ahead of time because the price of vehicles is very likely to go up in the next 4 or so months. So we were able to use last year's contract pricing and save, we're guessing 10 to 15% on those vehicles. It didn't change the total amount allocated to fleet for fiscal year 25. We just, instead of saving for it, we bought some about 6 months early. I do want to highlight this. We have a new vendor that provides our auction services, and we recently sent quite a bit of equipment to auction. The revenue for this fiscal year is about $250,000. That also goes into that vehicle replacement account. That's not something we have a lot of control over. You'll see pretty good auction prices sometimes, not always so good the next time. So this is one of the few ways we're eligible to get rid of or allowed to get rid of equipment. We can also trade it in for new equipment, and we look at that on a case-by-case basis. If there's a good offer for a trade-in, we take that over what we think we might get at auction. Those all come to you for approval, by the way. That's not, we make recommendations, you all make the decision for what to do with the equipment. That is all I had tonight. Like I said, a short presentation, but if you have any questions,
Questions, John?
I'd answer them.
I do want to just clarify from the budget workshop that we just had, we're looking at potentially decreasing our vehicle replacement funding just to the $150,000. And I'm sorry if I misunderstood our conversation previously, but did you say that we were completely funded in our vehicle replacement fund? Because that perhaps indicates that we're not.
Going to back up to this slide for a minute. So what we project is that we need to contribute about $2.9 million every year into that fund on average. So we can have a low year as long as you make it up down the road. We currently have $12 million in that fund, which gives us a pretty good buffer for a lean year, which is what we're looking at this year for the budget.
And so you would not anticipate having the $19.5 million in this fund at any given time, which is what you said that the total value of our fleet is, right?
I do not see a reason we would need to have that much cash on hand to fund this. We need enough for weathering the lean years, and if something, our loaders are $250,000 each, so if they go down, we need to be able to replace them. We don't need that full replacement value, that $19 million.
All of the time, just in case, right? Okay, thank you.
Probably not be a good use of money.
Questions, John? Thanks, sir.
Thanks for your time.
Mayor and council comments tonight, I have none. Council comments?
I have a few.
Go ahead.
May I go? Or someone else?
No, go ahead.
If they want. I wanted to say thank you, Mr. Fair, to your team at the triathlon this weekend. I know it was the first one in a while, and it was super organized and amazing. Everyone was in such good spirits and so encouraging and fun, and it was really, really a great experience. And I was amazed to see all of the volunteers out there. And anyway, I just really want to say thank you to them, and I really appreciate them being out there on a Sunday. Yeah, thank you.
Did you participate?
Oh, yes, but not well. I wasn't the last person to come in, so there's that. I didn't drown in the river.
No DNF.
Yeah, but I think, if I may, Nathan, you're on the docket to do it with me next year. You don't know that yet, but just so you know.
You're right, I don't.
Yeah. And then I do
You
have
just told me you did it.
I do have some questions about the Meadow Grove kind of situation that we're dealing with. I was wondering if I could dive into that a little bit.
This is one we
or-
discussed in fairly good detail at executive session.
Yeah.
If council wants to discuss it, I guess we can, but thoughts?
How much time do you think? As we did have a lengthy discussion of it, 3 weeks ago?
Yeah,
With
and
a quorum of city council and staff. So I guess the majority of people sitting here want to break that open again, but we already.
yeah, Field was kind enough to recount that conversation to me in great detail, so it's actually sort of outside of what was discussed during executive session.
If it's new and exciting stuff.
Yeah, well, I mean.
You okay, Randy? You were there?
Yeah, let's hear what she has to say.
Okay, so what I would maybe request of the city staff is that if we could look into some of the processes that we had or events that happened early in the development of this neighborhood that could have put them at risk of being in the very unfortunate situation that they find themselves in with a non-functioning HOA, and then having a number of things that were in their PUD and development agreement not met, and yet still getting all of their permits and having the city sign off on everything that was done. So I'd be interested in getting more information specifically on the letter that was sent on December 31st of 2001. It looks like Mr. Seal was aware of a number of the discrepancies that weren't fulfilled, and then I didn't see any other letters happen after that with any communication with the LLC that was developing it, even though it's very clear in the letter that no further discussion after 10 days, no response would kick it to the legal department for enforcement, and it seems like perhaps that didn't happen. My other specific questions deal with the irrigation that was set up on that neighborhood. So somehow their irrigation got connected to a separate HOA. So they actually don't have the ability to water part of the land that they're responsible for. And I think Mr. Manley sent an email as well in 2001. It looks on May 4th. He was aware of that issue, and so I was curious about any follow-up with that, and it still isn't resolved. The water is turned off to that piece of property. And then, of course, I would really like a detailed timeline of what was agreed upon, like the development timeline, and then how it actually went, and if that is something that is normal processes in developing a subdivision, to kind of go out of order a little bit. And that could be okay. It's not my area of expertise, but it seems like perhaps that contributed to the issue that they found themselves in. And then also I'm curious about how the city enforces and makes sure that the HOA that we demand that these neighborhoods set up so that they can take care of their shared property is actually set up appropriately, because I think very clearly in this instance we required that they did it, and then they didn't do it all of the way, and so now we have a handful of residents that are stuck in a very impossible situation. And so if I can list them out like that, my request is that City Council direct staff as one unified body, that perhaps we could get answers to those questions so that it could either be rectified and more specifically not happen again as we continue to have subdivisions.
Looked like you were about to talk.
No, I just was wondering if anyone else was going to talk. To make that type of a motion, this is not an agenda item tonight, so it would need to be added to an agenda for the next meeting to make a type of direction to staff. That was going to be my only point. So, but I wasn't sure if that was going to, the council was going to pick up the call and want to make that direction or not. So I was just waiting.
It would be a direction to add it to a future agenda.
Or is it, this is more general questions, which I actually really appreciate of, okay, how, in future developments and HOAs, how do we prevent these things from happening in the future? Is that more appropriate to have a workshop about that, to have a more open discussion on these issues before anything comes on agenda? Or?
Yeah, if the council wants to have a workshop on that, we can certainly schedule a workshop on that.
I think a workshop's a good idea. We could kind of step through the specific timelines that are typical and make sure everybody's clear on it.
I think for the most part, staff is recognized when issues like this come up, and not in this particular case maybe, but I know in larger developments when parks were going to go in and they're going to go in, but they don't do it till the last phase. And the people who bought the house that was going to be next to the park, their kids are grown and gone. And I think the staff's done a good job in requiring some of those improvements going up front. So I think improvements have been made, but that doesn't mean we're perfect.
Well, I think that this scenario is the exact opposite,
Yeah.
is it was required to be done in the beginning and then
Yeah.
it was not.
So that's what I said. I think there's improvements have been made, but we're not perfect. So I think we can make improvements. So I think workshop will probably be fine.
And to be conscious of what these residents are living through. So when we find the what is it, the Swiss cheese model of one hole after another, perhaps if that can be identified, then we can be more supportive of these residents as they work on establishing their HOA as requested by City Council.
Okay. Anything else?
Yeah, I would like to say a few things. I want to address Mr. and Mrs. Dorsey and your family and all those here in attendance supporting them. And I would just personally like to extend my apologies to you as a representative of the city. And I know it's difficult to assign any kind of intention to the interpretation of the ordinance that has so affected you. But I think it's just flat wrong to have put you through this. Specifically, Mrs. Dorsey, I know this is probably a very exciting time for you to get into a new home and kind of update it and make it much more livable into the future for you. And I don't want to be in a position that we have taken that from you. So hopefully by the end of this, that faith and trust in what we are trying to do here as a city and a county and work together, that can be fully restored again. That is my hope through the end of this process. Post Falls is my hometown. I've lived here in my entire life, and it is interesting to see, by the letter of the law, you're not necessarily a citizen of Post Falls when you're in these little pockets of land, but I would consider you close neighbors, and so we want to treat each other as such. And I really I appreciate you being here. I appreciate all of you who have come to represent them and support them. I think this is what city government is supposed to look like when we can come together and find a resolution to this. So thank you, guys.
Anybody else?
Yeah, I just want to echo thank you for showing up and participating. It's usually these meetings are not well attended, and we're here working on city business, and it's easy to feel like, oh, where are the citizens that we're kind of working on behalf of? So thank you for showing up and seeing what these meetings are actually like and kind of participating. And please continue to bring things to us if you have concerns, if you see something that you think is not working, because then we can go look into it and then make sure that things are working the way that they're intended to be working. So thank you.
We do not need an executive session tonight,
We do not, sir.
so the next motion is?
Adjourn.
All those in favor?
Aye.
Aye.
Meeting adjourned.